Hey folks, I'm attorney Roger P. Foley, and I'm going to tell you a quick story about a previous case I had some time ago. My client was driving down the interstate, came into contact with someone where the middle finger was used. I'd call it a road rage case. Um, my client tries to slow down, tries to speed up, tries to avoid the individual. Unfortunately, he brakes hard and he tries to get off the exit, and he's successful in getting off the exit. But the other aggravated motorist, I'd call him the aggressor stopped, backed up, got off the exit with him. Now my client ultimately ends up in traffic. This car turns over, blocks his path, gets out of the vehicle, and reaches into my client's car and starts punching. My client's scared, nervous, is now beaten up from inside the vehicle, tries to turn as the person drives back to, as the person walks back to the vehicle, and my client is trying to get him around him and ultimately ends up hitting that person's car. That person now gets back over to my client, grabs him, yanks him out of the car, and starts pounding on him. My client ultimately is able to escape, runs away. What happens? My client gets charged with aggravated battery with a deadly weapon, attempted murder. You're going, wait, how's that happen? Yeah, folks, that's how things happen. The police actually arrested my client for getting beat up in his car, but that's not what they're saying. They're saying that even if he got beat up in his car, the risk was no longer justified for him to accelerate and smash into the other car and almost hit the person. Yeah, crazy as that sounds. Luckily, the case all went away, but I wanted to talk to you about self-defense and justifiable use of defense. So let's talk about that real quick. I'm going to go to the jury instructions, right? And exemptions to presumption of fear in 776.013 subsection 2A-2D. The presumption of reasonable fear of imminent death or great bodily harm does not apply if the person against whom the defensive force is used or threatened to be used has the right to be in or lawful resident of the dwelling. Okay, doesn't apply. The person or persons sought to be removed as a child or grandchild doesn't apply. The person who uses, threatens, is engaged in a criminal activity, is using the dwelling, residence, occupied vehicle to further, doesn't apply. All right, so let's talk about it. It says a person who unlawfully and by force enters or attempts to enter another's dwelling, residence, occupied vehicle, oh, ding, 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 is presumed to be doing so with the intent to commit an unlawful act involving force or violence. Vehicle means a conveyance of any kind, whether or not motorized, which is designed to transport vehicle. So, what does the law say? If at the moment of the crime, where this other individual comes over to the car, gets into the car, and starts hitting my client, at that moment, my client can use force. Maybe he can run him over with the car. Maybe he can punch back. Maybe he can chop his hand off. Maybe he can even shoot him. Right? I would argue that he's in the defense of he's a life felony is occurring, a burglary battery, the entering of the vehicle with the intent to commit a battery therein. A burg battery is a life felony, and it's also referred to as a violent felony, and deadly force is used. So if at that moment my client would have pulled a revolver from his waistband from inside the center console and pow and shot, guess what? Good to go. Now, could he get arrested? Yes, but his day in court would arrive and we'd take care of business, right? We'd argue these facts. What if, however, after he was beaten, after the crime had been committed, as the perpetrator was walking away, what if my client then pulled the gun and shot him, or just pulled the gun. Guess what? It's not during the crime. It's not during the burg battery. So guess what? That now you're getting into a sticky situation that more likely you're going to be charged, and this self-defense is not going to be allowed. Why? Because the imminent harm, the immediate harm to the individual in the car who's already gotten beat up. It's moot. He's already gotten beat up. He's not at risk. Now, if he said, "Oh, screw you, F you," and the guy turned back around and came back at him while he was still in the car bleeding and beat up, pow, pow, guess what? Then he could defend himself. But what I'm trying to tell you, folks, is if after the crime is committed, someone spits in your face, someone slaps you, someone punches you inside your vehicle, and they exit away, well, stand your ground doesn't apply. Are you defending yourself at that point, or has the threat of harm already come and gone? That's the question, folks. So think about it. Self-defense, that's the law. I'm attorney Roger P. Foley. If you didn't know, now you know.